And we will now continue reading into evidence in this new section, Item 28. Item 28. Principal makes oath that on the date of November 26, 2009, a Thursday, I went to the Australian Federal Magistrates Court in Parramatta. I went, and I'm just adding this for you the jury, and you the public. I went with head held high. I went in to do battle, to do my bit, just like many Anzacs before me stormed the beaches of Gallipoli, fought like demons in Tobruk, or fought in the hell that was the Kokoda Trail. Many Australian men died for my freedom. Many men died defending my parents and their generation when they were defenceless children. In 1940, my father was 3 and my mother was 1. Now, here I was, with tyranny being introduced by treacherous, treasonous traitors who called themselves Australians. It was my turn to storm the enemy lines, only I was afforded the comfort of an air-conditioned room, and my weapons were my voice and a video recorder. I was spared the deserts, the jungles, the bullets and the bombs, but the situation was very much the same. I was putting my life at risk and I knew it. The New South Wales Police and ASIO have killed many a man like me. I know it, they know it, now you know it too. Men like my step-grandfather took vows to face all enemies, foreign and domestic. And on November the 26th, 2009, I took my place next to those brave Anzacs prepared to put my life on the line against a domestic enemy. The legal fraternity in the form of one David Dunkley and the Australian Federal Police by the first name callings of Christopher and Andrew. Okay, I've accidentally repeated 28. So my apologies, I've accidentally repeated 28. Item 28, an accidental repetition. Principal makes oath that at or about 9:50 a.m. Paul Lalage came to see me outside the courtroom and told me 2 things. 1, that he had given my documentation to David Dunkley and Louise Henderson. 2, that he had asked for 2 Australian Federal Police officers to attend the meeting so that there would be no trouble. I assured Paul that today I had come in peace. I assured him I was here to collect evidence, not to use force. He expressed pleasure at this comment. I then went over to introduce myself to the Australian Federal Police officers and to explain to them what I was doing here today and why I was doing it. I told them I had come in peace and I was here to talk. They seemed reassured that I approached them politely and professionally. Principal makes oath that at or about 10:05 a.m. an administrative assistant called for the legal entity, Mr. Peter Nolan, to enter the room. Okay. Item 30. Principal makes oath that the video recording that is provided as an attachment is the true record and only true record of what was said inside the court. The transcript was altered in a criminal act and had to be reissued. There are still false statements in the transcript. Principal makes oath that all words he spoke are on the video recording. The slightly false transcript is available in the attachment named as follows: 06 transcript of court meeting.pdf. Note to the jury: I have prepared a commentary on the transcript of the court meeting, and this will now be read into evidence. I also recommend that you now watch the full video of the court meeting with the transcript on the screen as well as follow with the transcript in front of you, so that you can follow along with what happened in the court meeting. This video will now transition to the discussion of the transcript and will also present the full court meeting in video. This ends this section of reading the items into evidence and into the public record. We now transition to the transcript and to the video. Thank you. Okay, I'm now going to read into evidence the not the entire transcript of proceedings. There is a video which I recommend you watch as a jury member. I recommend you watch the video with the transcript attached, or have the transcript sitting next to you while you watch the video. It's a relatively short video. It's only 40 minutes long, and I flew from London to Sydney return to capture that 40 minutes of video. That 40 minutes of video is the single most important piece of video evidence existing in Australia, which demonstrates the criminality of the Australian Federal Magistrates Court. The most important demonstration of the criminality is right towards the end of the video, and it is where David Dunkley refuses to answer the question, are you serving under oath today, twice. Now, you are sitting on the jury, you may not understand this, so I will explain it to you, okay? And you can verify this with any police officer, basically, or your expert in common law who will be assigned to you by the secretary. That is, if you are a public officer, let's say a police officer or a magistrate, you hold that office under an oath of office. That is, to become a magistrate, you must make an oath. And when you are serving in the public office of that magistrate, you must be serving under oath. You are to have your oath with you at all times. You are supposed to carry the actual oath around with you. And when you are presiding as a judge or a magistrate in your court, your oath of office is supposed to be there with you. Your oath is bonded by an amount of money. If anybody catches you breaking your oath, then you forfeit the bond to the person who catches you breaking your oath. That's how that works. When you are asked, are you serving under oath? If you are serving under oath, you have an obligation at law to say yes. And if you are asked, please recite your oath and tell me what your oath is, you are under obligation at law to recite the oath of office that is the office that you are operating at that time. You are under an obligation at law. Now, just to let you know that I understood this, I discussed this with the two Australian Federal Police officers who were sitting in the courtroom. I discussed this with them during the break in proceedings. Both officers, Christopher and Andrew, confirmed that they knew and they understood that the magistrate was required to say that he was operating under oath and required to recite his oath should I so ask him. They agreed and said that was the situation. They were federal officers. They had been trained. That's what they were required to do. Okay. So when I asked David whether he was serving under oath, and I asked him twice, I took a quick look over my left shoulder to see what those guys were looking like, and they were shocked and stunned. They were absolutely shocked and stunned. Okay. So they knew. They both knew, because I told them at the break that I was going to ask David this question, and I predicted at the break that David would try and run straight over the top of me and not answer the question. And both of them said no, he will answer the question because he's operating under oath. And they were shocked to the core. Now those two gentlemen should have immediately stood up and gone and arrested David Dunkley for the crime of impersonating a public officer, because that's the crime that he was committing at that point in time. So I have, to the right on the video, you will see about a dozen people sitting in the gallery, and to the left, my left rear, you see the two Australian Federal Police officers. Okay? So it is this video is an incredibly important piece of evidence. So I would suggest you watch it very closely. What I'm going to do before you watch it is I'm just going to walk through the script a little bit and make my comments, and then you can watch the video. Now clearly the video is presented as is. It was just done on a little handheld recorder, so we don't get to walk into court with great big video cameras and all the rest of it. That would have been confiscated. After I walked into the court, took my position, I pulled out a small handheld recorder. They're called flip recorders. They're about the size of a half pack of cigarettes, and so it was quite discreet. but it was understood that I was recording, and it's understood that it was understood that I was recording because in the court order that David Dunkley wrote, he claimed that it looked like I was recording the meeting on my cell phone or something like that. And the little flip recorders look very much like a small cell phone. Okay? So, you know, they're talking about transcript material in any form by any means without seeking proper prior permission of the family court, etc. This is all rubbish. Okay? This first piece is rubbish. This never happened. I did not address David Dunkley until I had my video recorder going. At that time, Jennifer and Sarah Bevan were already sitting in their seats. Nice of the courts to say that you cannot have a recording device and then they will tell lies on their transcripts. So the transcript is, this part of the transcript is a lie. Okay? None of that happened. This is where the truth is starting to be told. I started out here. So this is where the truth is starting to be told. As you can see from the video evidence, I made this opening statement. These were the first words I spoke inside the courtroom. Okay? Now, I was nervous and confused as to what exactly was happening because I'd never been in a situation before. I'd only been to court twice before, once to challenge a speeding fine from a lying police officer, and once to have my wife advise a magistrate that she had lied to the police in order to frighten me, and that ended up in me being arrested. Going to court like this was stressful and a difficult experience. I was also very jet lagged. I had actually flown from London to Sydney just 3 days earlier, in preparation for this meeting. So I had flown from London to Sydney. I was living in a hotel, and I was very jet lagged as well as stressed and all the rest of it. Okay. I also understood that I was placing my life at risk by walking into this court and video recording it, because what I was hoping to do in the court meeting was to catch David Dunkley committing a crime on video, which I did. He committed the crime of impersonating a public officer. When the trial of David Dunkley comes up, the jury will be asked to remember the circumstances under which I was taking on this criminal cartel, and that all mistakes were indeed honest mistakes. The fact that it is more than 3 years later now and no other man has emulated this achievement yet is testimony to the fact of how much courage and bravery it takes to walk into a court knowing you're risking your life and video recording what's going on and standing your ground. No other man has done that since in a family court matter, right? I rather thought that men would be following my lead quite readily. Okay, so any mistakes I made were honest mistakes. In the early part, I didn't realise that the courtroom was not the court, and that the court itself was beyond the balustrades, and that I never entered the court at any stage. David gave this away during the meeting. Okay, so from the video you can see I stand behind the balustrades, and I never at any time enter the court. I've entered the courtroom, but I've never entered the court. And at one stage David said, "Everybody can see you've entered the courtroom." And when he said, "Everybody can see you've entered the courtroom," I wondered why he said courtroom and not court. And then I looked where I was standing, and I noticed I was still outside the balustrades. And so I had never at any time entered the court. Okay? So never at any time can David Dunkley claim anything about obtaining jurisdiction. And in the court order, you will see David Dunkley actually claims that I at no time denied the jurisdiction of the court or challenged the jurisdiction of the court, which is ludicrous once you watch this video. So David makes many attempts to talk me into taking a seat and therefore, quote, boarding his ship, while all the while refusing to agree to the contract that I may do so with my property rights intact. He wanted to say that stepping into the court signified boarding his ship, and that he is the pirate of a captain's ship, and that's their interpretation of it, and by stepping into the court I would be waiving my property rights. That's what he was claiming. Now remember, on the 24th of November, 2 days earlier, I had issued the default judgment to Louise Henderson to say she did not have the right to have my house, have the proceeds of my house. Okay? So you can go through all this. So he's asking whether I'm relying on any documents, and I said I'm not relying on any other documents to do with the Australian Federal Magistrates Court, and the point is the court is a private company run for profit and control of the people. If you agree to use their documents, you agree to be a slave. And I had my documents to be delivered to David, remembering that Paul Lalage claimed 10 minutes before we went into the courtroom that he had given a copy of all my documents to David Dunkley. So on the video, which you are about to watch, when David Dunkley says, you know, this may proceed on an undefended basis, he already had copies of my documents. So he was lying while he's sitting there on the stand. Okay? He is again offering for me to waive my property rights. When you know what he's saying, it makes sense why he keeps offering. So those documents aren't relied on by you. If that's the case, then you won't have any documentation before the court. And my comment is, I had documents to put before the common law court, but this court was operating in Uniform Commercial Code, and I had reused the jurisdiction of that commercial court. So he says, well, it's a matter for you either to give me the documents now or the case would proceed on an undefended basis, says David Dunkley. So undefended? Who says I'm accused of anything and need to defend myself from anything? Okay, so he's claiming that I may go forward on an undefended basis, but I'm not. What am I accused of that I need to defend? So you think about that. Why is he saying I need to defend myself? Okay. So I said to him, you have no right to proceed with this case on an undefended basis, David. I have submitted my claim of right to the Queen, the Prime Minister, the Attorney General and the Governor General, and they have consented by acquiescence that you do not have a right to provide judicial, and I got a mistake, I've changed it to adjudication services to me unless I consent. Okay, so here I point out how David has no right to proceed in this meeting on an undefended basis, since the Queen et al. Had already agreed that these courts and their statutes have no authority over me. And if David is to claim authority over my property, he needs the Queen to explain why she did not rebut my affidavit and default judgment. Since he has a sworn allegiance to the Crown, he is beneath the Crown, and he must do as the Crown has agreed to. This statement is my clear rebuttal of the jurisdiction of David's private little court to force adjudication services over me and my property. It is in his order issued on the 19th of February 2010, David makes the claim that I at no time rebutted or challenged the jurisdiction of the court. Well, here it is in their transcript that I did this, and it is on the video evidence. This proves beyond doubt that David lied on his order as to the basis for his judgment. If men put up with such blatant lying by magistrates, they deserve their slavery. Please note the clear denial of right to provide adjudication services. I got it wrong in the first speaking and said judicial. Realizing my mistake, I corrected myself to adjudication services. These courts offer to the public domain adjudication services, just like McDonald's offers hamburgers. And if you avail of their adjudication services, then you agree to their fees, which are astronomical, by the way, and you agree to their decisions. Why would any man agree to this? These magistrates are there to apply common law, not this la-la land UCC rubbish they dish up. Okay? So David says, well, sir, you are an intelligent man and you know that's a nonsense. Here David calls my defense of my inalienable rights. Here David calls my defense of my inalienable rights and my claims a nonsense. A nonsense, my inalienable rights. So I make him the offer of putting his words on an affidavit. Notice he refuses that offer, meaning he knows it's perjury. So I said to him, well, if that is a nonsense, David, you are going to have to sign an affidavit under full penalty of perjury, full commercial liability, to say that is a nonsense. Are you willing to sign such an affidavit? And David said, no, I have just said that is a nonsense now. And so he's trying to repeat it's a nonsense to make it stick, and this is a lie, and I knew it. And I said, well, what you say doesn't matter. What matters is what you are prepared to put on an affidavit, David. So David, knowing he has just lied, I point out what he says is not relevant. It only matters what he's willing to put on an affidavit. Okay, so he's trying to dismiss my defense of my inalienable rights as nonsense, and he's not prepared to put anything on an affidavit. He's just sitting there talking. And basically, he's sitting there as a Burger King or McDonald's magistrate. He has no jurisdiction, and he's telling lie after lie after lie. That's what's going on in this video. And he says, "Sir, you either hand me the documents now or the matter proceeds on an undefended basis." Notice the threat. He has no right to do this and he knows it. So he tries to threaten me and frighten me. But I stick to my guns because I know he's a scumbag criminal. And I said, "Well, if you proceed with the matter on an undefended basis, David, I will charge you 1 million ounces of gold for enforcing an adjudication process on me that I have not consented to as a sovereign." Okay? So I was feeling far more confident and far better understanding what was happening by this stage. I decided to offer David a contract for 1 million ounces of gold to retain me in the room defending my rights. That's what that statement was about. And so I then said, he said, "Thank you." So I said, "I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way. So any way, shape or form, and I have plenty of witnesses who know this." So I just want to repeat this, reading this into the record for this case of Jennifer. I said, "I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way, shape or form, and I have plenty of witnesses who know this." Here is another clear rebuttal of the offer of adjudication services, again exposing the lies of the order of 2010-02-19. Where David Dunkley claims that I never denied the jurisdiction of the court. Okay, there I am denying the jurisdiction of the court. And David says, "All right, thank you, then the matter proceeds undefended." And I said, "Well, you will be charged 1 million ounces of gold for doing this. David, do you agree to that charge?" And here I made it very explicit that if he continues, he will be charged 1 million ounces of gold, and he's asked to enter into that contract. So let me just repeat this very carefully because it's very important. I said, "Well, you will be charged 1 million ounces of gold for doing this, David. Do you agree to that charge?" And he said, and it's on video and in the transcript, "Charge whatever you like." Okay, now I distinctly remember he said, "Yes, charge whatever you like." The transcript service seems to have dropped the yes, and you can get it on the video, right? So in order to confirm that the contract was entered into, I said, "Thank you for agreeing to the bill, David. Your audience here may wish to know why it is that a man cannot enter the courtroom with his inalienable rights intact." I was so astonished at the yes, I immediately wanted to make sure that the video recorded the fact he has agreed and give him a chance to object if he did not mean it. So I said, "Thank you for agreeing." Okay? So I said, "Thank you for agreeing, and your audience here may wish to know why it is that a man cannot enter the courtroom with his inalienable rights intact." So that constitutes a contract. He said, "Charge whatever you like," and I said, "Thank you for agreeing to the bill, David," and he didn't object. Okay? So in that interaction, which you will see on video in just a minute, David Dunkley agreed by contract for a bill of 1 million ounces of gold to provide his unwanted adjudication services to me. Okay? And also remembering that he had no right to be adjudicating on the property in the first place. Okay? So then David said something which gave the game away. I was still pretty confused at this point in time as to exactly what was happening, because it's meant to be confusing, right? David said, "The audience here observes that you are already within the courtroom, sir." "All right then, Miss Bevan, you better address me in respect of how we would get to a set of circumstances that would mean your client gets the totality of the asset pool," right? So my comment here is this. Now here is an important distinction which I had not gotten until David said this. He could not know I was still confused on this point at this point in time. I was standing just inside the door, which you can see on the video. I had been manoeuvred there covertly by only having one door open. I had intended to stand in the doorway, but while standing in the doorway, these criminal scumbags brought a crowd of students to watch the circus, and you can see to the right hand side in the video the crowd of students. I wonder what they made of it, right? So why did they bring a crowd of students in to watch this circus? Anyway, they were all standing behind me. I moved into the courtroom to allow the students in, and that was no accident. They did that to me. They were maneuvering me into the room, and then in this sentence, David tries to present in the courtroom as the same as being in the court. But it is not. The back area of the room is a public gallery, which is still, by the analogy, on land. The balustrade represents the edge of the ship. When David said this, I noticed that I was only in the courtroom and not in the court. This was a major victory for me and a major mistake by David to point this out. My confidence swelled as I realized what he had told me. Okay, I realized he had told me I was in the courtroom but not in the court. I was still standing in the public gallery at this point in time. Okay, so David gave that away. Now next, there's a lot of discussion during the court case. I will mention some things. Sarah Bevan said, finding in favour of the innocent party. And I want the jury to notice that the woman is the innocent party despite the crime she has committed. What does that make you the man? That makes you the man, the guilty party by presumption, because they're calling her the innocent party. But the question for the audience, the jury who is listening to this, what was I guilty of? Why was she the innocent party and why was I the guilty party? What was I guilty of? I was guilty of being a man, of course. Okay. So we'll go down a little bit further. So David Dunkley says, do you consent to the tender of the documents, meaning the documents by Sarah Bevan? And I said, no, I do not consent to the tender of the documents, David, meaning Jennifer's documents via Sarah Bevan. And David said, all right, on what basis don't you consent to the tender of the documents? And I said, I don't consent to the tender of the documents on the basis that I have not been given the opportunity to enter the court with all my inalienable rights intact. Okay? So I'm saying, I've asked you, David, many times over, and it's on the video, I'm quite happy to enter this court on the basis that you agree on the record, on my video, that I do so with all my inalienable rights intact, and you won't say yes to that. So I don't consent to the tender of Sarah Bevan's documents, Jennifer's documents, on the basis that I haven't been given the agreement to enter the court with all my inalienable rights intact. So everything presented by Sarah Bevan was not consented to and is dismissible. Okay? You, the jury, listening to this evidence, can dismiss anything presented by Sarah Bevan because David asked me if I consented to the tender of the documents and I said no. And so David tried to get out of it and he said, that's not a legal basis for the tender not to proceed, sir. And David tried to fool me on legalese. His claims that it's not legal, which is true, but I'm not subject to their legal system. So I said, that's the lawful basis for the tender not to proceed, David. And so I pointed out to David that my objection is the lawful basis, which is higher than legal basis not to proceed. So what does he do? He just ignores it. He says, all right then. And so I reminded him. I said, we are in common law jurisdiction, David. Okay? So he's saying that's not a legal basis, which is Uniform Commercial Code legal system, which is inferior to common law. And he went forward and tried to override me, and I pointed out to him, we are in common law jurisdiction, David. And when you get to the presentation by Robert McClelland, you will see Robert McClelland consistently references cases in Australia where the Magna Carta defines the basis of law in Australia and that the legislation must be consistent with that law. Okay? So you, as a layperson listening to this, you can speak to your expert in common law who will be assigned to you. He will tell you that Uniform Commercial Code must operate in harmony with the underlying system of law. And as far as the Commonwealth of Australia is concerned, the underlying system of law is the English common law founded on the Magna Carta. Okay? So I told David Dunkley that's the lawful basis for the tender not to proceed, David, and he proceeded anyway. So I told him we are in common law jurisdiction, David, and he proceeded anyway. Okay? Which he had no right to do. Okay, so then there was a break. In the break, I'd spent time talking to these two Australian federal police officers who said their callings were Christopher and Andrew. Amazing, because my middle name is Andrew and my oldest brother is Christopher, and I took that as a good sign. Anyway, I explained to them that this was all a lie and the courts were corrupt. I told them that in the second half I would challenge the magistrate as to whether he was under oath. One of the two, I forget which one by name, but it was a dark-haired one, said that magistrates were always under oath on the bench. I told him to watch what happened. What will happen. I told him that the magistrate would refuse to talk about whether he was under oath because he wasn't. I told him he was nothing but the captain of a pirate ship intent on plundering my property. He joked that they were just the hired hands and were there to do what the captain told them. These guys obviously understood that I was no, quote, threat of violence and that I was there as a patriot, though they also thought I was crazy. Okay? So, it goes on, and we do all this stuff, and you can probably read this for yourself. And I said, all right, do you want to do that now? And so, not in answer to that notice, I have plenty of documents that I wish to provide you. I was repeating, I have plenty of documents I wish to provide you. And he said, all right, do you want to do that now? Thank you. And I said, I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular, my property rights. So I make another offer to, quote, board his ship with my rights intact and point out that I am particularly concerned about my property rights. Now, I was having real fun by now. By now, I knew I had him. I knew I had him on video, and I knew that I had won this particular battle. So he said, and be very careful about listening to this. You, the jury, listen to this carefully. He said, yes, all right. So if you are going to produce them now, please. So David gets even more slimy here. He says, yes, all right, but he is not clear what he has said yes to. So I make sure I ask him what he said yes to. So I said, when you said, yes, all right, do you mean I may enter with my property rights and my inalienable rights intact, please, David? And he's caught out being a slimy bastard, and he says, no, I didn't mean that. I don't mean that. Okay? So here is his sliminess exposed. He meant yes to something else, but he would not elaborate what he was saying yes to. Okay, so are you men getting the picture in the audience? I say, I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular my property rights. And he says, yes, all right. So if you are going to produce them now, please. And I notice that he's being slimy, and I say, when you said, yes, all right, do you mean that I may enter with my property rights and my inalienable rights intact, please, David? And he says, no, I don't mean that. Okay? So he's saying, no, I don't mean you can board my ship with your property rights intact. If you board my ship, I'm going to claim that you don't have your property rights intact. That's what that means. So I then say, may I ask you a question then, David? Okay? Remember, I'm the master, he's the servant. And he says, no. So I said very politely, may I ask you a question then, David? And he says, no. Are you going to produce some documents in answer to the notice to produce? So I then said into the record, so I want it recorded that I asked politely, may I ask David a question? And he said, no. And so then he said, are you going to produce the documents? Now remember, he's got a copy of these documents that I had in my bag. Okay? And he keeps pretending that he doesn't have that copy. And he keeps saying, no, you may not enter my court with your property rights intact, If you want to enter my court, you must give me all your property so I can adjudicate on it. That's what he's saying. Now, you may not understand that's what he's saying, but you can check with your expert in common law and he will tell you that's what he's saying. So then I say, because he said no to asking him a question politely, I then say, is your oath in the courtroom today, David? Okay. He is by law obliged to say yes. Okay. I said, is your oath in the courtroom today, David? And he says, all right, I take it that means you are not producing. He didn't answer the question. He avoided the question. So I said, and I note for the audience that David has refused to answer the question, is his oath in the courtroom today? So he's not a magistrate. He's not a magistrate. When you ask a magistrate or a judge, is your oath in the courtroom today? He is obliged by law to say yes. David did not say yes, therefore he was not a magistrate. And most likely his oath was not in the court that day. So I note for the audience that David has refused to answer the question, is his oath in the courtroom today? So there are no documents in answer to the notice to produce. And I said, there are documents in answer to that notice, David. However, I will only present those documents in the case that my inalienable rights are intact. And then they go off on a whole bunch of other stuff, right? And then right down the end, we'll just go down to the end. And you can read these comments if you want. So, down towards the end, he says, well, I'm going to reserve, so you will have to come back in respect of that. Mr. Nolan, are there any submissions that you want to make? And I said, David, I have asked you to call me Peter. Mr. Nolan is a corporate strawman of which I'm the primary creditor and secured party. And for the record, are we on the record? I believe you have been recording, I was saying to the girl at the side. And David says, no, what happens here, Mr. Nolan, is that all proceedings in this court are recorded. So I said, okay, so for and on the record, David, are you operating under your oath today? Okay, this is my little bombshell endgame. David, are you operating under oath today? He says, Mr. Nolan, do you have any submissions that you wish to make? And I said, for and on the record, David, are you operating under your oath today? And David refuses to respond, and I looked over my left shoulder at this time to see the two federal officers staggered at what was going on. David says, I take it that therefore you have no submission that you wish to make. And I said, so let the record show that a sovereign, Peter Andrew Nolan, has asked David twice, is he operating under his oath today? And David has refused to answer that he is operating under oath. And it is my contention that he is operating as a private employee and therefore has no jurisdiction over my common law property rights. David said, there being no submissions and I reserve my decision, I will deliver written judgment on a date to be advised. And I said, well, David, should you choose to violate my property rights, let me hereby notice you that I will address those rights in a common law jurisdiction court. You may be charged with theft, you may be charged with violation of common laws. I have with me documentation to demonstrate that I am the primary creditor of the corporate strawman, Peter Andrew Nolan, and I have the highest claim. I have not been able to present this documentation because the judge, and I meant magistrate, is acting, and I correct myself, the magistrate is acting as a private employee of a private company, not as a common law judge. He is in fact impersonating a public servant. And I read that into the record. So you, men sitting on the jury, David Dunkley was committing the crime of impersonating a public servant. That's what he was doing. And I have two Australian federal police officers by the name of Andrew and Christopher who witnessed that. Okay, all we need to do is find out from Paula Large who Andrew and Christopher were. So then there's a summary by me where you can go and read that. So this ends the reading of the transcript of the court meeting into the record of this case, and the next thing you will see is the entire video of the court meeting. Thank you very much for listening.
I did. There is one additional order on this minute order in relation to an account in Jersey.
In that account?
Yeah, sorry, the dollars, right? 1,458 Australian dollars using a conversion rate of 1.6 euro.
14.
Yes.
Right, so she relies on the minute of order. The affidavit sworn the 10th of November, and a financial statement which was sworn on the 20th of November.
That's correct.
Is that the documents?
They are.
Now, Mr. Nolan, there was filed for you an application for final orders on the 3rd of December 2007, and there was also filed on that day an affidavit that you swore on the 13th of June 2008, and a financial statement that you swore on the 28th of November 2007. And there don't appear to be any updating documents since then. Are you relying on any other documents?
I'm not relying on any other documents to do with the Australian Federal Magistrates Court.
You're relying on those or not on those?
I'm not relying on those documents to deal with this situation today, and the question I have is, may I take a seat with my inalienable rights intact?
You can take a seat whenever you like.
When you agree that my inalienable rights are intact, I will take a seat, Your Honour.
It's a matter for you as to whether you keep standing. So those documents aren't relied on by you. If that's the case, then you won't have any documentation before the court.
I have documentation to present before a common law court, Your Honour, but I'm not going to enter until such time as you agree to the contract that my inalienable rights are intact.
Well, it's a matter that you either give me the documents now or the case would proceed on an undefended basis.
You have no right to proceed with the case on an undefended basis, David. I have submitted my claim of right to the Queen, the Prime Minister, the Attorney General and the Governor General, and they have consented by acquiescence that you do not have a right to provide judicial adjudication services to me unless I consent.
Yes, well, so you're an intelligent man and you know that that's a nonsense.
Well, if that is a nonsense, David, you're going to have to sign an affidavit under full penalty of perjury, full commercial liability, to say that it is a nonsense. Are you willing to sign such an affidavit?
No, I just said that it is a nonsense. Now,
Well, what you say doesn't matter. What matters is what you're prepared to put on an affidavit, David.
All right, so there's no documents on which you seek to rely.
I have documents on which I seek to rely, but you have not agreed to the contract that I can enter the courtroom with my inalienable rights intact.
So you either hand me the documents now or the matter proceeds on an undefended basis.
Well, if you proceed with the matter on an undefended basis, David, I will charge you 1 million ounces of gold for enforcing an adjudication process on me that I have not consented to as a sovereign. I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way, shape or form. And I have plenty of witnesses who know this.
All right, thank you. Then the matter proceeds undefended.
Well, you will be charged 1 million ounces of gold for doing this, David. Do you agree to that charge?
Charge whatever you like.
Thank you for agreeing to the bill, David. Your audience here may wish to know, why is it that a man cannot enter the courtroom with his inalienable rights intact?
The audience here observes that you're already within the courtroom, so. All right, then, Ms. Bevan, you better address me in respect of how we would get to a set of circumstances that would mean that your client gets the totality of the asset.
In order to do that, Your Honour, I must tender a reasonably significant amount of documentation. In relation to the Button-Kellner and Weir principles, my case is that the husband, by failing to disclose his assets, has left the court in a situation where, as those cases say, you should not be unduly cautious in making an adverse finding in favour of the innocent party. In addition, Your Honour, the husband himself in various emails has made reference to his own income earning ability, in reference to his, in effect, disruption of the company of the parties, instant business intelligence. There are other factors to take into account with regard to the Irish proceedings. My client's evidence is those Irish proceedings are now concluded and cannot be reinstated.
Well, they can't be because, I mean, this is the venue for the hearing.
It is, and this is the appropriate jurisdiction, I must mention, Your Honour. Your Honour, there's also emails from the husband in which he makes reference to having removed certain amounts of money, such as €7,000 and €10,000 out of the jurisdiction, that being the jurisdiction of Ireland.
All right, we better tender that material.
Thank you, Your Honour. I have on the front of it a list of those documents. I estimate that it would take you approximately an hour to read. However, I can indicate that in relation to the husband's emails, although it's certainly outside of the usual practice, those emails are quite lengthy and I have put highlights around the relevant sections. I don't ask you to read the whole of the emails, but simply those highlighted sections.
So, the material that's produced in the blue black folder, you're seeking to tender that?
I am, Your Honour.
Mr. Nolan, there's sought to be tendered before me some material in a binder. Do you wish to be heard in respect of the tender?
I do wish to be heard, sir, and I wish you to agree that I can approach the court with all my inalienable rights intact.
So, do you consent to the tender of the documents?
No, I do not consent to the tender of the documents, David.
On what basis don't you consent to the tender of the documents?
I don't consent to the tender of the documents on the basis that I have not been given the opportunity to enter the court with all my inalienable rights intact.
That's not a legal basis for the tender not to proceed, sir.
That's the lawful basis for the tender not to proceed, David. We are in common law jurisdiction, David.
And on the basis that there's no objection that is sustainable at law, I mark as Exhibit A the material in a ringback folder. Yes. Anything further, Ms. Bevan?
Would you prefer to have my submissions now, or I can?
I know, I better read all of that material.
Thank you, Your Honour.
All right, we'll adjourn while I go off and read.
On stand, please.
This honourable court stands temporarily adjourned.
Now, thank you.
I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular my property rights.
Yes, all right. So if you're going to produce them now, please.
When you said yes or right, do you mean that I may enter with my property rights and my inalienable rights intact, please, David?
No, I don't mean that.
May I ask you a question then, David?
No, are you going to produce some documents in answer to the notice to produce?
So I want it recorded that I asked politely, may I ask David a question? And he said no.
Are you going to produce the documents?
Are you? Is your oath in the courtroom today, David?
All right, I take it that means that you're not producing.
And I note for the audience that David has refused to answer the question, is his oath in the courtroom today?
So there's no documents in answer to the notice to produce.
There are documents in answer to that notice, David. However, I will only present those documents in the case that my inalienable rights are intact.
Yes, Ms. Bevan.
Thank you, Your Honour. Your Honour, in the documents produced, tendered, there wasn't a reference to the €10,000, I believe. I have one email and one letter to tender in addition in relation to that. It's only the upper part of that email I see, Marie Jo.
Mr. Nolan, there's produced or sought to be tendered an email from Sarah Bevan to SBA Mail dated the 25th of November 2009. Do you want to be heard about that being marked as an exhibit?
David, I would like to participate in a friendly and peaceful way in this conversation. However, I'll only participate in this conversation with my inalienable rights intact. By the way, I wish to declare that Mr. Peter Andrew Nolan is a corporate strawman fiction, and I'm the primary creditor and secured party for this corporate fiction. You may call me Peter, David.
Then I mark as exhibit B the email from Sarah Bevan dated the 25th of November 2009 to SBA Mail. Mr. Nolan, there is a letter from the Royal Bank of Canada to Mrs. J. Nolan dated the 20th of March 2008 that sought to be tendered. Do you want to be heard about that?
David, I've asked you to please call me Peter. Mr. Nolan is a corporate strawman. It's a dead entity. I will speak as Peter Andrew of the Nolan family, the primary creditor and the secured party for the corporate strawman, Mr. Peter Andrew Nolan.
Then there being no objection, I mark as exhibit C the letter from the Royal Bank of Canada dated the 20th of March 2008 to Mrs. J. Nolan. Ms. Bevan, in reading the material, there's an email called dublinolans@gmail.com. I presume that's your client's email.
It is, Your Honour, yes.
And then there's some emails to a Bruce at GS
one takes into account the add-backs included. And in that regard, I should have an amended case outline, which I should have handed up earlier. There are only some minor amendments on it, which I've underlined, is to add in one add-back of $7,000.
That's the money that was transferred.
€7,000, yes, was. And the net is underlined on the two last pages.
Yes.
Your Honour, the effect of the orders sought by my client, if the add-backs are taken into account, and I'll address you on those shortly, effects a split to my client of the assets of 83%, 83.3% to be precise. My submissions take two alternative approaches, or indeed a combination of both. That is, that these orders are warranted on the basis of a Black and Kellner or Weir type approach, as I highlighted earlier, that being that the court should not be unduly cautious in making findings in favour of my client as a party. The alternative is that there should be a significant adjustment pursuant to section 75(2), specifically in relation to subsection B. Your Honour, in relation to the assets, the Australian assets and the relatively minor assets in Ireland are easy to identify. There is also, the husband asserts in emails, a loan from his brother. The wife has given evidence that that loan was in fact a gift. And the husband's own emails, as contained in the tendered documents, refers to that amount not needing to be paid back.
It's the purchase contribution that comes in on his side.
You do, Your Honour, and I'll address all contributions in that respect when I get to it. But given that the husband has not put any evidence with regard to the amount of the loan, or the interest on the loan, or the terms of repayment, and also given the nature of his emails as contained in the tender Exhibit A, my submission is that this is not a loan. It should not be treated as a loan of the parties. In fact, it's just simply a contribution issue that I'll come back to. You're in relation to the Black and Kellner considerations. You have before you emails from the husband where he refers to removing €7,000 out of the jurisdiction. He also refers to paying that amount to a colleague in Germany, as he says. You also have the email Exhibit B, which refers to him removing €10,000. He says to apply it to the statement of family. My client's evidence says different. And in fact, my client's evidence is the only sworn evidence you have before you, Your Honour. In addition, Your Honour, there was also what I would submit is a very significant asset, that being the company Instant Business Intelligence. My client's evidence is clear that that business traded well, afforded them a very decent income.
I don't have any figures in that.
You don't?
There's no profit and loss statements. There's no taxation returns.
You have nothing in that regard, Your Honour. My submission in that respect is that you cannot know anything about the company. And in fact, the company is now dissolved. But in any event, there's no means by which that this court can say, I consider it had, or at some stage, a value of X. That,
I mean, it could simply just be a trading company that they conducted a business in. It had no other intrinsic value of its own.
as in just a simply income earning vehicle.
Yeah.
It could, Your Honour, but it also could have been a significant asset itself. Tied in with the company is the reference the husband makes in various emails to the software, that he has software. And one of his emails refers to, no court can force me to sell my software. My submission in that regard, Your Honour, is that he's making a concession that there is an asset. Again, you have absolutely no means of knowing what that asset is worth. And that is because of the husband's complete failure to disclose any relevant material in this case, Your Honour. You're in circumstances where you have no knowledge of what the asset pool is. this is a case in my submission that falls clearly within the guidelines set out in Weir and Wee, and in my submission should give you, or should lead you to not be cautious at all in making findings in favour of my client. When I referred earlier to my client receiving 83% of the property pool, that is of what we know there is and the easily identifiable add-backs. Your Honour, in respect of the add-backs, it's my submission that where you have in effect concessions by the husband that those amounts have been removed for his own purpose, have not been expended on my client's evidence for the sake of the family, but presumably have been used for his own personal purposes, or simply, as he says, paid to someone else, that being a colleague in Germany, then the appropriate course is to treat those as add-backs rather than as some sort of wastage consideration under Cavalli. Your Honour, in relation to, actually I'll come back to the Cavalli issues later, Your Honour. In relation to those add-backs, there is then the consideration of whether they are to be treated as an asset rather than under Section 75(2). In that regard, given that the amounts are clearly identifiable, and my client's financial statement sets out the means by which she has converted the amounts to Australian dollars, that being 1.616, I believe, it is appropriate, and in fact is really the only course open to the court in respect of how to treat those factors. Your Honour, in relation to the contributions, my submission is that this is a case where there should be a 55-45% split in my client's favour. Your Honour, the husband, if he was to present a case, might have two factors that he could argue in relation to contributions. That being that he provided support to the wife's two older children from a previous relationship.
A Robert type.
Sorry?
A Robert
Yes.
type.
However, that's mitigated by the fact, Your Honour, that my client received child support from the children's father, and they were only resident with the parties for a limited part of the marriage. The other factor, Your Honour, is the gift from his brother. He said it's a loan, but as submissions made earlier, it's appropriate to treat it as a gift. My client's evidence is its amount of $15,000 that was advanced very early in the relationship. On the basis of it being a relatively limited amount, and the amount of time and the nature of the contributions that have flowed since that time, my submission is it would really have little, if any, weight pursuant to his and his considerations, Your Honour. On the contrary, Your Honour, my client has made significant post-separation contributions. And I should add, when I'm jumping to post-separation, apart from those two factors that I've just mentioned, I would say that the contributions during the marriage would generally be considered 50-50. The husband was the breadwinner, my client was the care of the children and the domestic duties. She did that, and that's how the parties organised their lives. It's a clear case where, apart from these other factors, it would otherwise be a 50-50 case, Your Honour. Since separation, my client has continued to care for the children and has continued to make all payments for the care of the children. She's given evidence that in caring for the children, she must pay private school fees. And she's now also supporting Josephine, the older child, who is now at university.
She's over 18.
Sorry?
She's over 18.
She is over 18.
She's a special needs child.
She's not a special needs child, no. I will come back to her in relation to Section 75(2), though, Your Honour. In addition, the contributions that my client has made post-separation, in my submission, have been made more onerous by the conduct of the husband. The husband has embarked on a course of conduct which is designed, or I'll draw that, the husband's embarked on a course of conduct which has had a significantly negative effect on my client. She says in her affidavit that she's received an extraordinary amount of emails from the husband. And on that point, Your Honour, I must correct one point in my client's affidavit. She says she received what numbers in the thousands. Since swearing the affidavit, she's taken the arduous task of actually counting those that she still has, not knowing if any were deleted when the husband accessed her account. And she has counted 550. That doesn't include the emails sent by the husband to various friends and colleagues and family members. Whatever the number, whether it's 550 or in the thousands, it is an extraordinary number of emails, all taking a very particular approach, and all the combined effect must have an effect on my client. You already don't have in evidence, but my client instructs me today that she's been in counselling for 18 months. We've now completed that counselling in order to deal with the treatment she's had at the hands of the husband. Your Honour, as you'd be aware, Kennan & Kennan gives authority to where, in circumstances where there's been domestic violence, but not only domestic violence, also other conduct, which is not limited by description. The factors such as those should warrant a consideration of weighting the contributions in favour of the, essentially the victim now. Your Honour, if ever a case fell into the category of conduct which is designed to, or which has led to making the innocent party have a more onerous job in doing their day-to-day life, this is the case. Your Honour, the number of those emails, the nature of those emails, the widespread nature of those emails can only have an effect on my client. Admittedly, you don't have expert evidence before you, but in my submissions, it's a very clear-cut case that by simple common sense, the effect of those must have had on my client. Your Honour, in relation to Section 75(2) factors, my submission is that there would be a very weighty adjustment in my client's favour. If we started from a proposition of 55-45 contributions, my submission would be that it would be appropriate to adjust perhaps even by up to 40% in my client's favour. Your Honour, the subsection B refers to the income and earning capacity of the parties. The husband, throughout his emails, has referred to his income earning capacity. In one of his more recent emails, he's referred to the ability to earn €200,000. That, in rough figures, equates to, 30 figures in my head, about 320,000 Australian dollars a year. He's referred to his consulting fee of €1,000 a day, which is 1,600 approximately a day, Australian dollars a day. If you don't consider that the property, that the business is indeed property, and instead was an income earning vehicle, the fact of the husband's income earning during the relationship suggests that he now has that earning capacity now. Whether he chooses to exercise that or not, as a result of other conduct that he chooses to take, is a matter for him. However, he has that capacity. Your Honour, in addition, my client has the care of the younger child of marriage, she's under 16. As her evidence says, she's required to pay private school fees for him, and also maintain him in the usual way. In addition, subsection D refers to the commitment to support others, as does subsection E. She's given evidence that she's paying Josephine's university fees. As someone on a student permit, she has limited work rights and therefore limited ability to support herself. In addition, Your Honour, subsection K refers to the effect of marriage on the earning capacity of the party. My client gives evidence that throughout the marriage, from very shortly after the younger child's birth, by agreement, she was the one looking after the children. She was the one who stayed home and devoted herself to the care of the children in the house, and effectively enabled the husband to go out and earn the amounts of money that he did, which then puts him in good stead to earn the same similar amounts of money now.
I just don't have any evidence as to what he had.
What he had. In my client's affidavit, Your Honour, there is some evidence.
It's a statement.
was within her knowledge to make those statements, and therefore, as the only evidence we have in this matter, my submission is that it's strong evidence that you're able to rely on. She says that the company paid the husband between $6,000 and $8,000 a month, so €6,000 and €8,000 a month, and that the company earned $220,000 in consulting fees and an additional amount in software sales. Coming back to the effect of the marriage on my client's earning capacity, the absence for her from the workforce for such a length of time can only have a negative effect on her earning capacity. Subsequent to separation, she obtained work as a carer, which is a relatively unskilled position, and now works in office administration. She's detailed what her income is, and it's certainly not anywhere near what she says the husband's income was. Your Honour, another consideration under Section 752 is the child support paid by child support paid for the children. Josephine is now over 18, but she was under 18 at the time of the separation. Joshua is still under 18. My client's evidence is that apart from 3 payments in November 2007, she's received no money whatsoever for the children. She has had to maintain the children since separation, and I think it's very clear, my submission is there is no hope that the wife will ever receive any child support for Joshua. Your Honour, turning lastly to Section 752(0), I mentioned before the Cavalli principles in respect of wastage. Your Honour, the husband has engaged in conduct that I would submit falls within the Cavalli principles in relation to two items. That being the company, if Your Honour accepts or is willing to make a finding that it may well have had a value, then the husband's actions since separation have led it to now be dissolved and for it to have no value, one would assume, at all. In addition, Your Honour has evidence about the actions the husband took in relation to the controlled monies account. The sale proceeds from the sale of the tenant Hills property were pursuant to orders of 16 June 2008 to be placed in the controlled monies account.
The best that they can get for that would be something like about 2 or 3%, isn't it?
In a cash management account, it now has gone up previously, which is relates to most of the period, would be about 3%. By my calculations, being that it's approximately 6 months, it would be around about $4,500. Your Honour, there's very clear evidence from the husband's emails in respect to the controlled monies. I can say that there was an attempt by my client to have the registrars sign the required documents pursuant to Section 106A. There was a difficulty in that regard as a result of the notation made by Judicial Registrar Johnston that the agreement that Watson Prey would keep it, the husband's former lawyers, was a notation only. That was therefore unsuccessful, Your Honour.
That probably brings it to an end.
Sorry?
That probably puts it to an end. Yeah, but if it's a notation only, I mean, I'll have to look at that.
It's unfortunate that in what happened it was only notation. There was certainly no issue at the time, and it wasn't, that particular part wasn't drafted as consent orders, it was added by Judicial Registrar Johnston. Your Honour, turning lastly to justice and equity in respect to the property issues. While my client's application for effectively 83% of the assets is under what I have suggested might be the appropriate percentage for her, it is all that she can get. There is absolutely no point in making an order for the husband to pay her any money because I think we can all accept that simply will not happen based on the conduct of the husband to date. Your Honour, the husband has chosen not to give evidence today. It can be as a result of what can only be described his contemptuous attitude towards this court. That the husband is presented with that attitude should leave the court no concerns as to failing the husband in terms of providing him justice and equity. Your Honour, there are 2 additional orders sought that have only lately been sought in respect to parenting. Your Honour, that is sole parental responsibility and an issue about the passport. While sole parental child passport expires in January, Your Honour.
Travels on an Australian passport.
He does, Your Honour. Your Honour, there has been no Section 60I certificate. My submission is that this is a matter where mediation is, the requirement for mediation should be waived because of the simple impracticality of it. Your Honour, the husband, the only evidence I'm relying on in order to support the sole parental responsibility is the husband's own emails, where he refers to the children as his former children and also makes a comment of the leeches called wife and children. The husband himself has disowned the children. I can say to Your Honour that those two emails that I provided you are not the only, there are only emails in that regard, there are numerous emails. I didn't see any point in tendering all of those for all the emails, Your Honour. Your Honour, those are my submissions. I do have an application and separate costs though.
I'm going to reserve so Mr. Nolan, are there any submissions that you want to make?
David, I've asked you to call me Peter. Mr. Nolan is a corporate strawman of which I'm the primary creditor and secured party. For the record, are we on the record? I believe you have been recording, madam. I believe you have been recording.
No. What happens here, Mr. Nolan, is that all proceedings in this court are recorded.
Okay, so for and on the record, David, are you operating under your oath today?
Mr. Nolan, do you have any submissions that you wish to make?
For and on the record, David, are you operating under your oath today?
Take it that therefore you have no submissions that you wish to make.
So let the record show that a sovereign, Peter Andrew Nolan, has asked David twice, is he operating under his oath today? And David has refused to answer, is he operating under oath? It's my contention that he's operating as a private employee and therefore has no jurisdiction over my common law property rights.
There being no submissions, then I reserve my decision. I believe a written judgment on a date to be advised.
Well, David, should you choose to violate my property rights, let me hereby notice you that I will address those rights in a common law jurisdiction court. You may be charged with theft. You may be charged with violation of common laws. I have with me documentation to demonstrate that I am the primary creditor of the corporate strawman, Mr. Peter Andrew Nolan, and I have the highest claim. I have not been able to present this documentation because the judge is acting, magistrate is acting as a private employee of a private company, not as a common law judge. He is in fact impersonating a public servant.